Hello and welcome to Holland Estates. I'm Stuart Clark.
And I'm Kira Domratchev.
And you're listening to episode number 611. Hello, Kira.
Hi, Stuart.
Nice to be podcasting with you today.
Likewise.
I know, as we are still podcasting from our fun virtual, whatever the heck we want to call it, homes. We're podcasting from our homes, but we're happy to be sharing our estates knowledge with the world today. So we have an interesting case, actually, kind of topic to talk about from Australia, and the case name is Grove for Simon Dirk Kenworthy-Groen, which might be the longest estate or a case name I've had in a while. And we'll get the citation up for anyone who wants to look at it. But the basic topic that it touches upon, which I think is always, comes up all the time for us in our files. People ask it all the time, and people often, get it wrong, is what material does a drafting lawyer / estate trustee on behalf of a drafting lawyer have to produce surrounding wills? Do you have to produce the previous wills, will drafting files, notes, records, et cetera, and how the heck do you go about getting that kind of material in the context of estate litigation?
Yeah, so this is a very interesting case. It's similar. The process is obviously a little bit different. This is actually an Australian decision. Obviously in our case, if you start a proceeding, you usually get an order giving directions. That's where we'll discuss that more at length. That's where you sort of get orders for the production of solicitors' files and that kind of thing. It sounds like in Australia, you sort of have to bring some sort of motion before you start litigation. And so this is what happened here based on a reading of it, or an application, I think it's addressed there. Basically, this deals with the estate of William Grove. He was an 86-year-old. He was diagnosed with gastric cancer. It said here that he chose naturopathic remedies instead of chemotherapy. And then, quickly thereafter, his health sort of declined. And he had 3 children, Andrew, Simon, and John. Simon was appointed as executor under the deceased will that was dated September 11th, 2015. The deceased then died on October 30th, 2015, so shortly after this will was signed, and probate was granted. So again, similar to what we have here on February 8th, 2016. This is an application by John, one of William's children, against Andrew, one of William's other children, and it's essentially a claim of undue influence. So various allegations that the will does not represent his wishes, that Andrew unduly influenced him into making a will. And as part of this sort of pre-litigation application, John seeks details with respect to preceding wills. So there's 2 categories here. There's preceding wills. He's saying there were lots of wills done before this last will. And 2, he's obviously seeking the drafting solicitor's file. So that would include, wills, memoranda of wishes, or statements of testamentary intention, whether signed, unsigned, executed, draft, interim, final, or however described, it says here, prepared by the late William Grove or his solicitors in 2015. And so the question before the master here is, should this be produced? And quite topical for Ontario as well, because that's often a question for us as well.
Spoiler alert, in this instance, the judge ended up actually ordering the production of the materials and kind of went through the whole analysis of, if there's privilege, who's it repose in, what is duty of confidentiality, can they get access, kind of stuff. As Kira kind of touched upon, I'm not sure it's a direct comparable procedurally from Australia to Ontario, because there's a kind of weird pre-litigation thing. It almost seems like he's not yet actually challenged the will, but he's somehow already in court and making allegations regarding undue influence, and saying, I need these documents to go ahead with my claim, which isn't quite the same in Ontario. Ontario, you kind of have to make your claim and then say why these documents are relevant to your claim and get them. But the kind of broad brushstrokes of, can you get a lawyer's file appear similar, right? It seems universal, and it kind of raises universal concepts and topics regarding estate law. And it all kind of comes down to, from a lawyer's perspective, the duty of confidentiality and privilege, right? Are these previous legal records and wills and notes and materials were produced by a lawyer still confidential and privileged? And if so, can it be waived? And must they be produced? And that, is exactly in Ontario's wheelhouse here. And, it's always kind of important to remember, whenever you're talking about, can I get access to a lawyer's file surrounding estate litigation, is, well, who holds privilege and to whom is the duty of confidentiality still owed? So all lawyers in Ontario are governed by the rules of professional conduct. In those rules is included a duty to maintain everything as confidential as between yourself and your client. And then obviously then there's privilege then, which exists in kind of the litigation realm as well, if any documents were produced in the context of a retainer. But for the most part, when drafting wills and all these notes, the privilege and confidentiality is owed to the deceased person. They were the one who hired the lawyer. They're the ones who did the will, did all this material. And the duty of confidentiality and privilege survives death. So you as lawyers still owe that duty post-death. And to the extent that someone can now, step into the shoes of the deceased, that is typically the executor, estate trustee, who can step into the shoes and say, yes, I waive privilege. Yes, I waive confidentiality. No, I don't waive it. No, I'm not willing to produce it. And then let the fight ensue.
Right. And so the interesting question is, of course, if the estate trustee can waive privilege, which technically they can, are there any considerations of potential liability? So if somebody comes knocking on your door and says, I need to see the drafting solicitor's files, could beneficiaries or the court say that that should not have been produced without court order because maybe you're encouraging litigation that would not have resulted had you not produced these records? I feel like that's something that, we often see as a firm, people making these requests, and it's just important to consider that perhaps a court order is needed.
Yeah, I mean, it's always tough. This is always one of the toughest topics to discuss with clients who are estate trustees in the face of a disgruntled beneficiary or next of kin, or someone who's kind of poking around the edges, looking like they may challenge a will, but haven't actually taken that step yet to actually challenge the will or actually confirm that they're going to challenge. It's all this, well, I want more information. Well, I want to satisfy myself that everything was done proper. And if I'm okay with that, I'll step back, but I'm not actually willing to make that final call yet to challenge the will. And it's a tough situation, right? Because we talked about a second ago, privilege reposes in the estate trustee. The estate trustee's authorities itself derive from the will. So if someone's actually challenged the will, that's an easy scenario. Because at that point you say, well, my authority as a state trustee has been questioned. It's no longer for sure that I can give my consent on behalf of the deceased to whom privilege is owed. So whether or not I consent to this doesn't really matter anymore because it's not my consent to give, it's the deceased who I may or may not represent. So therefore we need a court order. That's the the easier situation to resolve right now. The tougher one is that pre-litigation one, right? Where, okay, I'm the named executor. I'm probably going to have authority to waive privilege on behalf of the deceased. You are saying you may challenge this will, but you haven't actually done it yet. So there's a good chance I still have that authority, but it may be questioned later on. Do I volunteer this information to you using my hypothetical authority as named estate trustee in the hope that upon giving it to you, you realize, oh yeah, you're right, I'm going to lose this fight. It's not worth having. Or do you tell the person to go away in a grumpy manner, say, no, either challenge the will or don't challenge the will. I'm not going to help you sue me. And this is a fishing expedition and all the other grumpy language that we throw in our letters all the time to say, why you shouldn't challenge this will. And it's a kind of a case by case tough call because it's not definitive here.
Right. I mean, it really is the decision of the estate trustee of how much risk they want to carry, right? Because at the end of the day, you often see people who simply don't want to spend the cost of starting litigation because in a way you kind of have to, and the way that the structure is, and not sure that much can be done about it, but lots of people have to, if you want to start litigation, you might have to start it before you really have the information to really assess the strength of your case. And so, a lot of the time when people make these claims and say, I want this, I want that, they simply want to mitigate their own risk. They don't want to start the litigation and potentially be responsible for costs. And I'm not just speaking for the costs that they might incur. Starting litigation might go nowhere, but maybe costs of the estate or costs of the other parties if things sort of go sideways. And so it's a serious consideration. And certainly for drafting solicitors, if somebody comes knocking on your door asking for your file and that, you should probably be calling Law Pro before agreeing to release anything like that.
Exactly. And yeah, so let's pivot for a second. That's exactly right. So it's one thing if you're the executor in that scenario saying, what the heck do I do? And there's that gray area of, do I comply with the request or don't I comply with the request? If I'm going to give them something, how much do I give? But if you're a lawyer here, so that the first scenario assumes that the estate trustee probably already has these previous wills. It may have some material already. It's a question of, do I give it to you voluntarily or don't I give it to you voluntarily? Well, as lawyer, if you get a request from someone, either the executor or, someone, a beneficiary or someone else saying, give me this stuff. I mean, that's when you as a lawyer got to kind of be really top of mind of who do I owe a duty of confidentiality to, and has enough been given to me to comply with the request. And as we touched before, privilege is and confidentiality is owed to the deceased and the estate by extension. So if you're not certain that the person who's making that request has the authority of the estate, whether because a will is being challenged or is likely to be challenged, or whether because the person is not the executor, your safest thing to do, I mean, one, contact Law Pro for sure, but then the safest thing to do with your Law Pro counsel is probably to say, get me a court order. I mean, I have enough question marks here that I don't feel comfortable handing over my file material to any of you right now, because it's not clear who, if any of you, have authority right now. And I'm going to require some kind of court order saying that my duty of confidentiality isn't waived, and that I have the ability to hand over my file materials, failing which I'm not sure I can.
So, I mean, at the end of the day here, it looks like in this particular case, the productions were ordered. But it's interesting because the process is a bit different at the end. The master sort of made comments about costs. And so if ultimately this applicant did not move forward with the will challenge, they basically had to cover the costs of this particular proceeding. And then if they did proceed with the will challenge, then the cost would be determined as part of the overall proceeding. So I think it's just a little bit different in terms of how people go about it, because I still see affidavit evidence here presenting some sort of background information for the judge to even consider whether there's enough substance here to order these records. But it's interesting because the master did make comments about, something about the hostility of the relationship between the respondent and the deceased, but really it was just based on an affidavit of the applicant saying that they didn't have a positive, that there were no examples or anything like that. So I thought that was interesting. Certainly frequent changes to the wills were noted as one of the reasons that, things looked a little bit suspicious, I suppose. And then that was that. So I suppose this is a 2021 decision. So I wonder if there will ultimately be a decision published if something does go forward there.
Yeah, who knows? I mean, yeah, it's not exact perfect comparable situation, procedurally to Ontario, but you can see the similarities, right? Someone challenges a will, they're still not quite sure, what the parameters of that challenge may be. They may not even have the previous will yet, and they're asking for that material. And here, as Kira said before, kind of dealt with early stages, order giving directions. But, hey, it's an interesting comparable. It makes you kind of go top of mind. And it's always, in all these requests, always good to remember, who do I need to ask permission to get this kind of material? Who has privilege? Who has confidentiality? And once you kind of wrap your head around that, these procedural issues hopefully can resolve themselves fairly easily. Otherwise, you get yourself into some messy, fun situations.
Right, and then just consider, who do I need to potentially consult? So where maybe Law Pro.
Law Pro and speed dial. Interesting case. So we'll get the citation up hopefully on our kind of blurb that goes along with this. But yeah, when in doubt, call Law Pro if you're a lawyer, and if you're involved in a will challenge, make sure that you turn your mind to who has the ability to waive this kind of privilege and confidentiality.
Or the early stages of a will challenge before any allegations are really made, but questions are being asked.
Interesting stuff. Well, thank you, Kira. I think that probably brings us to an end of our podcast today. And thank you to our listeners out there. Until next time, I'm Stuart Clark.
And I'm Kira Domratchev.
Thank you for listening.